Hi everyone, welcome to Forensic Enigma. So today we are going to see about consent in medical practice. We are going to see what is consent, why consent is needed in current medical practice, what is the legal validity of the consent, who has the capacity to consent, and development of consent over the years, principles of consent in Indian law, and also some interesting case extracts. So what does the Constitution of India Article 21 says? No person shall be deprived of his life or personal liberty except according to procedure established by law. So it also includes autonomy, self-determination, dignity, and privacy. So here, the word autonomy stands for the person's or the individual's ability or the right to decide for himself. So in Latin, the word consentare means to feel with or to agree with. Indian Contract Act says two or more persons are said to consent when they agree upon the same thing in the same sense. So the same thing here is the treatment procedure or the any diagnostic procedures. In the same sense means the doctor should make the patient understand. So better it is explained in the language and the adequate information should be given to the person in which he understands. So there are two types of consents, implied consent and express consent. So implied consent is there is no formal agreement between the patient and the doctor. The patient just walks into a clinic and submits himself for physical examination. So that is implied consent. So what is express consent? There are two types. The consent can be expressed in two forms, oral or verbal consent. The other one is the written consent. So oral or verbal consent is always obtained in presence of a disinterested third party, usually for withdrawal of blood samples or any gynecological procedures, radiological examination. Oral consent can be obtained, but you should document it in the case sheet. So what is written consent? It is obtained in cases of medico-legal examination like injury, sexual assault, alcoholism, age determination, dental or surgical procedures, general or spinal anesthesia, invasive diagnostic procedures like lumbar puncture or bone marrow aspiration. So this is the charter of patients' right. Actually, this charter has to be put in display in hospitals. So among these rights, we are going to see about the right to informed consent. So what is informed consent? Informed consent, it should be a process. It should be mutual communication. It is not just an event like document signing. You should make the patient understand the procedure and the outcomes of the procedure. So the information provided should be simple, easy to understand, and also you should list any possible major complications. You should enable the patient to determine whether to undergo or decline the procedure. So what is doctrine of informed consent? It says the consent should list the condition of the patient or nature of the illness, purpose or necessity for further testing. Suppose if the patient comes to your clinic for with complaints of fever, should explain the nature of the condition to the patient and the necessity for further tests like CBC or any Vidal or any test you are going to conduct on the patient. You should explain the necessity for further testing. So natural course of the condition and possible complication should be explained to the patient, nature of the procedure or treatment proposed, risks and benefit of the treatment proposed, risks and benefits of alternative treatment or procedure, and prognosis in absence of intervention. So the condition has not been medically intervened, how the prognosis will be, that has to be explained to the patient. And duration and approximate cost of treatment should be explained to the patient. And also expected outcome and follow-up should be explained. So these all include the doctrine of informed consent. So informed financial consent. The doctor should always discuss about the range of reasonable treatment options with fee estimates. So whenever a patient approaches a doctor and the doctor suggests a surgery or a procedure, the first question the patient asks to the doctor is, doctor, how much will be the cost of the treatment? So always the doctor should be aware of the treatment cost or the procedure cost. Okay, in case suppose the doctor is unaware or unfamiliar with the treatment cost, he should advise the patient to contact the finance department or billing section. Informed refusal. So even after the doctor has explained everything about the procedure and without the performance of that procedure, the prognosis of the condition will be very bad. The patient, a competent patient, has the right to refuse treatment. So he is competent patient, that we will see later. So no forceful approach should be applied to obtain consent. So inform the patient about the potential risks of refusing the treatment. Get the patient signature along with a witness. So document each step of the refusal process. So this is known as informed refusal. So why consent is necessary in medical practice? Can we operate on a patient without his consent? So what will happen then? So in civil and criminal law, Indian civil and criminal law says performing a procedure without consent is considered a battery or assault. So the doctor is liable under civil and criminal law. So failure to provide required information before taking consent of the patient for treatment, it is considered as a medical negligence by Indian Medical Council regulations. So not taking consent is considered as a deficiency in medical services under Consumer Protection Act. So this way we have to take consent, otherwise action can be taken upon the doctor for not taking the consent of the patient. So what is valid consent? A consent is said to be free when it is not caused by coercion, undue influence, fraud, misinterpretation, or mistake. Legally valid consent should be voluntary or free. Always there should be the willingness of the patient to undergo the treatment. Capacity, ability of the patient to understand the nature and consequences of the treatment offered. And the patient should possess proper knowledge about the treatment. That is, appropriate and adequate amount of information should be given to the patient. So what is an invalid consent? Whichever consent is that is not an informed consent is invalid. And the consent given for committing crime or illegal actions such as criminal abortions is invalid. Obtained by misinterpretation of fraud, and one given without legal capacity. That is, a consent given by a minor or insane person who is incapable of understanding the nature and consequences of the procedure. So what are all the exceptions to informed consent? They are emergency situations. Whenever the life of the person is in danger, then we need not go for or ask for consent of the particular patient. So therapeutic privilege in cases of malignancies or suicidal tendencies, consent is not needed from the patient. You can always communicate it to the relatives or the next of kin. So what is therapeutic waiver? A competent person waiving his right to consent. For giving placebos or prescribing placebos, you need not need consent of that particular individual. Mostly in cases of de-addiction it happens. So, and also for prisoners, consent is not needed. So what does Indian Contract Act Section 11 says? Every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So it says the person's age should be more than 18 years in India. Okay, that is the age of majority, and then he should be of sound mind. Okay, so and then he should not be disqualified by the law for entering into a contract. So this person is considered as a competent person. So a person is said to be of sound mind. Who is of sound mind? Any person who can understand the purpose of making a contract at the time of making the contract and capable of understanding it and forming a rational judgment. Okay, he is known as a person of sound mind. A person who is usually of unsound mind, but if he is of sound mind at the time of making the contract, then the particular consent is valid. Suppose a person usually of sound mind, but at the time of making a contract, he is of unsound mind because of intoxication or something else. If he makes a contract at that time, then the contract is not valid. So section 90 IPC says consent known to be given under fear or misconception is not valid. Consent of insane person. The consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and consequences of that to which he gives his consent. That is, he could not understand the nature and consequences of the procedure to be performed. Always consent of a child less than 12 years is not valid. So if a child is more than 12 years but less than 18 years, the child can give consent for physical examination, but not for surgical procedures. If it is more than 18 years, then the person can give consent for surgical procedures. So section 88 IPC says act not intended to cause death done by consent in good faith for person's benefit. So here, doctor is performing a surgery with the consent of the patient. Then even though the performance of surgery is a dangerous act, but the doctor has committed no offense. So section 92 IPC says act done in good faith for benefit of a person without consent. Such as emergency situation, surgeries can be performed by the doctor without consent of that particular person in order to save his life. So the doctor has committed no offense in such cases. What does Mental Health Care Act says about consent? It says a person with mental illness has the right to consent to make decisions regarding his mental health care or treatment if such person has the ability to understand the information that is relevant to the treatment, and also appreciate any reasonably foreseeable consequence of a decision or lack of decision on the treatment or admission or personal assistance, and also if he is able to communicate his decision by means of speech, expression, gesture, or any other means. So it says that even though the person is with mental illness, the person with mental illness has every right to consent. So if he understands the nature and consequences of that procedure and he is able to communicate the his decision upon the consent. So Indian Medical Council Professional Conduct Etiquette and Ethics Regulations 2002, it says that before performing an operation, a physician should always obtain the consent in writing from the husband or wife, parent or guardian in cases of minor. If the patient is a major, then from himself. And also if the operation may result in sterility, then consent of both husband and wife is needed. So there is always a tug of war between the professional paternalism and patient's right to autonomy. So what is professional paternalism? Here, the doctor decides what is right for the patient. So that is professional paternalism. What is patient's right to autonomy? That is, the particular patient is considered as a capable adult making of decisions for himself. Okay, so that is patient's right to autonomy. So there is always a tug of war while obtaining consent, the principle of consent, okay, between these two. So initially, it was in UK, the prudent doctor test was used. So it was the Bolam test in 1957. So Bolam was the patient's name. So Bolam versus Friend Hospital Management Committee was the case. Here the patient went for ECT procedure. So no muscle relaxants was given to him for the procedure. The patient had some violent seizures during the procedure and sustained some fractures. So later on, he went to the court. What the court decided was whether the doctor had practiced as accepted by a responsible body of medical profession. So at that time in England, there were two schools of opinion regarding ECT. So one suggested no muscle relaxation should be given because there is a chances the patient may die. The other school said that the muscle relaxant has to be given to the patient before ECT. So here the court decided the doctor is not negligent because he has followed a standard practice as prescribed by a responsible body of medical profession. So what happened in 1985 in a Sidaway case, that is Sidaway application of Bolam test. Here they introduced the concept of informed consent, the real consent. The patient should be explained about all outcomes and the complications and the risks involved in that procedure. Here, the doctor is considered as a professional man of greater prudence who can decide what information to disclose to the patient. Here, the doctor is considered as a professional man of greater prudence to decide on what to disclose. So, what does 2015 Montgomery case says? Here, the court started moving away from the Bolam test. The court thought that Bolam test can no longer be applied in cases of medical negligence. A more rigid or more clear rule has to be established. So the doctor is under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. So this has to be clearly explained to the patient while obtaining the consent. So in US, prudent patient test is followed for obtaining consent. So that is the Canterbury test. So it says that all standard information has to be disclosed to every patient, and the extent of such disclosure is neither left to the discretion of the doctor nor he can take defense of reasonable medical practice. So here the doctor cannot decide what information to be disclosed to the patient. So there is a standard set of information which has to be disclosed to every patient because in case suppose the doctor didn't follow this, then the doctor is liable. Common medical legal situations and consent. So in case of abortion, if you are going to do an MTP, then the consent of a female is mandatory, whereas the consent of the husband is not necessary. So in case of any contraceptive sterilizations or procedures involving limitations of sexual functions, consent of both husband and wife is needed. So in case of impotence and sterility or a rape accused, when asked by court or the police, the procedure can be performed after obtaining from the particular person. Suppose if the person refuses, then necessary force can be applied and evidence can be collected. So artificial insemination, in case of AIH, that is artificial insemination homologous, both husband and wife has to consent. In case of AID, artificial insemination donor, husband, wife, donor and donor's wife also has to consent. So in case of a rape survivor or rape victim, the consent of that female is mandatory. It should be obtained in presence of a witness. In case of refusal to consent, an informed refusal has to be obtained and documented in the case sheet. Okay. In case of drunkenness, if that particular person is conscious and capable of giving consent, then consent can be obtained from that particular person. Suppose if he is unconscious, you can do the examination and treat him without consent. But later on, you can disclose the findings to that patient. So in case of accused, consent need not be obtained. So now let us see about some interesting case extracts that happened in India and what does Indian courts has to decide upon the principles of consent. So in the case Samira Kohli versus Dr. Prabha Manchanda, the initial consent was obtained for diagnostic laparotomy, but hysterectomy was done. For no consent was obtained for the procedure of hysterectomy. Here, the court held the doctor liable. So additional surgery without consent, however beneficial to the patient in saving expenses, pain, time and suffering, is not a defense unless there is an imminent threat to the life of the patient. So only in emergency situations, such procedures can be performed without consent of the person. Otherwise, even though the procedure is a time saving, it saves pain, etc., it is not a defense. Okay, then the doctor will be held liable. So in the case Dr. Thomas versus Eliza, Court held the doctor was guilty of negligence for not operating on a patient with life-threatening peritonitis with perforated appendix. Here, the patient was not in a condition to give consent and the relatives were not available. But this is not a defense. This is not a defense. The doctor cannot say, I didn't obtain the consent because the patient was unconscious and the relatives were also not available. So the doctor cannot say that. In case of emergency situation, the doctor has to act promptly and treat the patient. So that is what the court said. So in case of Devi versus West Midland Health Authority, so the patient admitted for a minor operation in the uterus. Sterilization was done without her consent, stating that future pregnancy may cause uterine rupture. Here also the doctors were held liable and damages were awarded as there was no immediate urgency to perform the operation. Okay, so even though the doctor thought two surgeries can be done at a time, because it would be beneficial to the patient, but there was no emergency to perform that operation. So that procedure cannot be performed without consent of this person. Okay, so the doctor was held liable and damages were awarded. Here the damages means compensation was awarded to the patient. So in the case Dr. Sailesh Shah versus Ephraim Dayanand Rathod, appendicectomy procedure was performed without written consent and no explanation was given to the patient. In this case also, the National Commission, that means Consumer Dispute Redressal Commission, National Commission said the doctor was deficient in service and held liable for compensation. Okay. This is under Consumer Protection Act. So that is why it was said that the doctor was deficient in service. So in another case with Gujarat State Commission under Consumer Protection Act, hysterectomy was done in a married woman who was 13 weeks pregnant with two minor children, a boy and a girl, after getting her consent. Here the consent was not obtained from the husband. So already I have told you, for any contraceptive sterilization or limitation to sexual functions, consent of both husband and wife has to be obtained. Whereas in this case, this particular person was bleeding profusely, and an emergency hysterectomy has to be done to save the life of that patient. So it was done by an eminent gynecologist. So qualified person has performed that procedure under emergency situations in order to save the life of the patient. So here there is no negligence on the part of doctor. So in another case, Nizam Institute of Medical Sciences versus Prashant. So the complainant underwent surgery for excision of tumor, but it resulted in complete paralysis where the consent was only given for biopsy and not for the surgery. Here the court held the doctor liable because consent for biopsy cannot be taken as a consent for surgery. So the doctor was held liable. The Consumer Right Protection Act, the Consumer Dispute Redressal Forum actually offered compensation. The compensation was not enough for the patient, so he again went to Supreme Court and he got a compensation of nearly 1 crore rupees, okay, with interest. So the consent plays a major role, okay. So Ram Bihari Lal versus Dr. J.N. Srivatsava. A suspected case of appendicitis was admitted for surgery. Consent for appendicectomy was obtained. But after opening, the appendix was normal. There was some issues with the gallbladder and gallbladder was removed without patient consent. Here also the doctor was held liable because the consent obtained was a particular procedure, but a different procedure was performed without the patient's consent. So here the doctor was held liable. So in case of CA Muthukrishnan versus M. Rajalakshmi, the patient actually has to undergo a CABG procedure, but he was not in a state to give consent. He was unconscious, okay. So it was an emergency situation. So the consent was obtained from his wife and was held valid. So the current situation in India, the courts have decided that for Indian scenarios, we cannot go for Canterbury, which is a rigid procedure or a more stricter rule of consent. We have to go with the Bolam test because the relationship between a doctor and a patient is of fiduciary nature. That is, it is based on trust. So we can apply only Bolam in current situation. Also, the court said the point that nowadays, because of increased commercialization of this medical field, there may be a time that we may move towards the Canterbury rule in future. But for now, we go with the Bolam test. So that is what the court said, the courts observed in regarding the principles of consent. So thank you all. I hope you had an idea about consent in medical practice, and also where to apply the types of consent, what consent has to be taken, and regarding the validity of the consent. So thank you all for your support. Thank you.